Good morning, everyone. I'm going to call the Assembly Committee on Judiciary to order. Madam Secretary, would you please call the roll?
Assemblywoman Bilbray Axelrod. Here. Assemblywoman Cohen. Here. Assemblywoman Gonzalez. Here. Assemblywoman Hanson. Here. Assemblywoman Hardy. Assemblywoman Kasama. Here. Assemblywoman Krasner. Here. Assemblywoman Marzola. Here. Assemblyman Miller. Here. Assemblywoman Wynn. Here. Assemblyman O'Neill. Here. Assemblyman Orentlicker. Here. Assemblywoman Summers Armstrong. Here. Assemblyman Wheeler. Here. Chairman Yeager.
Here. Please mark Assemblywoman Hardy absent excused. Everybody else is here. That means we do have a quorum. Good morning to committee members. Good morning to our guests here in the room in Carson City, to those joining us on the Zoom, and to those who might be watching over the internet. It is day 103 of the 81st session of the Nevada Legislature. Before we get started this morning, just a few quick housekeeping matters for anyone in the room with us, or if you could please silence your devices. For anyone on the Zoom, if you could please remain on mute unless you are going to speak. And then for anyone who might be answering questions about work session bills today, if you could please remember to state your name before you speak. We do expect courtesy and respect in our interactions with one another. We don't always agree on policy. That's perfectly acceptable, but we need to make sure we're being respectful of one another, of the legislative process, and of our very hardworking staff. And then finally, many members up here are accessing this meeting using multiple devices, so please don't see it as a sign of disrespect or inattention if members appear to be looking away at times. So committee, that'll take us to our agenda. As you can see, at this time we have 9 bills on the work session agenda. So we'll take the bills from the top, and just so members know, members of the public, members of the committee, you can find the work session document on Nellis as a complete document, and then each bill has its own separate exhibit as well. So if you'd like to follow along there, that would be a great way to do it. So with that being said, let's start with Senate Bill 6. Ms. Thornton?
Thank you, Chairman. Diane Thornton, Committee Policy Analyst, Legislative Council Bureau for the record. Our first bill is Senate Bill 6. This bill was sponsored by the Senate Committee on Judiciary on behalf of the Nevada Supreme Court and heard in committee on April 27th. This bill makes various changes to revisions governing orders for protection against high-risk behavior. There's one amendment to the bill. Senator Scheibel proposed an amendment, and the mock-ups on the following pages. First, it revises Section 1.3, subsection 1B, by adding that upon the request of either party and showing of good cause by that party, the court may schedule a hearing in accordance with Section 1.5 of the Act. It revises Section 6, subsection 1A, to require that the court must issue an extended order if it finds by clear and convincing evidence that the person poses the risk of causing a self-inflicted injury or a personal injury to another person by possessing, controlling, purchasing, or otherwise acquiring any firearm. Third, it revises Section 9, subsection 2, to provide that the law enforcement agency must serve the adverse party personally with the application and any supplemental documents that were submitted to the court. And fourth, it amends Section 9 by adding a new subsection 8 to provide that the court may withhold or redact certain information from the application. Upon the request of the adverse party, the court must provide the party or the party's attorney or agent with an opportunity to interview the applicant or witness in an environment that provides for the protection of the applicant or witness. And lastly, any information or documents redacted must be maintained in a confidential file and be made available to the adverse party to inspect, copy, or photograph prior to the hearing. Thank you, Chair.
Thank you, Ms. Thornton. That was a very long one to start with. Hopefully the rest of them won't be quite as long. Committee members, I know we're just seeing the amendment probably mostly for the first time, either last night or tonight, but are there any questions on Senate Bill 6 as detailed in the work session document? Assemblywoman Cohen?
Thank you, Chair. Senator Scheibel and I had been discussing I wish I'd printed it out. Sub 8 in Section 9. Thank you. The interview portion. So I just wanted to confirm that the interview happens if just at the courthouse before the hearing, if there is certain information that was redacted from the application for the high-risk protective order.
Melanie Scheibel for the record, and yes, that is correct. This language is borrowed from the criminal statute, and it was approved by the Public Defenders Association, as well as the 8th Judicial District Court, as well as the AOC, the Court Administrative Offices, and you're exactly correct. The idea is that we don't want to be serving people who are the subject of a high-risk protective order with information that is incendiary, that is going to provoke them to retaliate against the person who is seeking the order. However, they are also entitled to have that information before they have to respond on the record to the allegations. And so there may be a circumstance in which the easiest way to facilitate that transfer of information is simply to allow the attorney for the person who the order is being sought against to just talk to the applicant for the order, and then the court would be able to set any parameters. You know, we have witness rooms in the 8th Judicial District. They might have a bailiff go with them. They might do it in the courtroom, but off the record, something like that, just trying to be accommodating of the unique circumstances that come with high-risk protection orders.
Okay, thank you.
Thank you for being here this morning, Chair Scheibel. Any other questions from committee members on Senate Bill 6 as detailed in the work session document? Okay, I don't see any additional questions. I'd be looking for a motion to amend and do pass.
I move to amend and do pass.
Have a motion from Vice Chair Wynn. We had like 3 seconds, I think, but we'll go with Assemblywoman Marzola. I think your second was the loudest. Any discussion on the motion? Assemblyman O'Neill?
Thank you, Chair, for the time. I'll be a no on this, but I want to explain, I really appreciate the work that's been done on it, moving forward with the senator. But I still know, and I understand that actually some of the amendments that various firearm groups have gone to a neutral position on it. I'll be a no because basically it's the whole premise that I still have problems with on Second Amendment rights in the process. So I just had to put that on the record if I may, Chair. Thank you.
Thank you, Assemblyman. Further discussion on the motion? I just wanted to say, Chair Scheibel, I appreciate you working on the amendment. I know there were a lot of interested parties on this one, and so thank you for bringing what appears to be consensus in terms of those who are actually in the courtroom trying to process these hearings, so appreciate it. Okay, committee, seeing no further discussion, again, the motion is to amend and do pass Senate Bill 6. All those in favor, please signify by saying aye. Aye. Any opposed, nay? So I have nays from Assemblyman O'Neill and Assemblyman Wheeler. Were there any other nays? Okay, I don't think so. So the motion does carry, and I will assign the floor statement on that one to Assemblywoman Bilbray Axelrod. We'll move along to Senate Bill 45. Ms. Thornton.
Senate Bill 45 was sponsored by the Senate Committee on Government Affairs on behalf of the Attorney General and heard in committee on April 16th. This bill changes the name of the Office of Ombudsman for Victims of Domestic Violence from the Office of Attorney General to the Office of Ombudsman for Victims of Domestic Violence, Sexual Assault, and Human Trafficking to reflect the expanded scope of the office to include the crimes of sexual assault and human trafficking, and makes conforming changes to the names, duties, qualifications. In addition, the bill revises the composition and duties of the Committee on Domestic Violence. The bill also revises the punishment imposed upon a person convicted of a first offense of domestic violence against a pregnant victim to require that the offender be imprisoned in a county jail for not less than 30 days, but not more than 6 months. The offender may be further punished by a fine of between $500 and $1,000 and must participate in weekly counseling for not less than 12 months at his or her expense. There's one amendment proposed by Assemblywoman Wynn. It proposed revising Section 7, subsection 4A to the bill to do the following. First, it revises the mandatory minimum from 30 to 20 days and removes the 6-month maximum for the first offense of battery, which constitutes domestic violence against a victim who is pregnant. And secondly, it deletes the proposed increase in the period of mandatory counseling for not less than 12 months, thereby restoring the requirement that the person must participate in weekly counseling sessions for not less than 6 months. You, Chair.
Thank you, Ms. Thornton. And committee, you may remember there was some discussion when we heard this bill about the mechanics of how it would work. And so I want to thank Vice Chair Wynn and Ms. Adair, who I think have figured it out to make sure that this is going to work given the way folks are supervised and the sentencing structure. So that is what you see in the amendment. But with that, I would be willing to take any questions that folks would have on Senate Bill 45 as detailed in the work session document. So are there any questions? Okay, I don't see any questions. At this time, I'll take a motion to amend and do pass.
And move to amend and do pass.
I have a motion from Vice Chair Nguyen. We'll give the second to Assemblywoman Gonzalez. Is there any discussion on the motion? Okay, I don't see any discussion. Again, the motion is to amend and do pass Senate Bill 45. All those in favor, please signify by saying aye. Aye. Any opposed, nay? Okay, motion carries. Everyone present voted in favor. And I'll assign the floor statement on Senate Bill 45 to Assemblywoman Kasama. Thank you. We'll move right along to Senate Bill 94. Ms. Thornton?
Thank you, Chair. Senate Bill 94 is sponsored by Senator Settlemyre and heard in committee on April 27th. This bill provides that an unlocked gate does not in and of itself constitute a nuisance. There are two amendments to this measure. The first one was proposed by Senator Settlemyre. He proposed clarifying when an unlocked gate in and of itself does not constitute a public nuisance, including a gate in counties with populations less than 100,000 must be placed and maintained on the road in a manner according to and consistent with specifications, standards, and requirements of the county developed under certain provisions in statute. And a gate in counties with populations over 100,000 must be authorized by ordinance and/or by written agreement with the county. Further, Senator Settlemyre proposed that it is not a public nuisance for a person to fence or otherwise enclose public land where fencing is required or authorized by the appropriate federal agency. And lastly, Assemblyman Ornlicker proposed deleting the language where vagrant resort is a public nuisance in Section 1, subsection 2G. Thank you, Chair.
Thank you, Ms. Thornton. And committee, you might remember this was the bill where we had some opposition testimony, and then we closed opposition and had to come back to opposition because there were folks that were in neutral but who were in opposition. And the reason I tell you all of that is the amendment that was proposed by Senator Settlemyre did earn the, I don't want to say a support, but certainly backed off the opposition to where they are in a place of neutral, if not support of the measure. So that is why you see the amendment. And then you may remember Assemblyman Ornlicker had a couple of suggestions on changing the vagrancy or the nuisance statute, and in consultation with Senator Settlemyre, we agreed to take out where vagrants resort as a public nuisance, but leave everything else in there, perhaps for a further discussion on another day. So any questions? We do have Senator Settlemyre here with us. Any questions from committee members on Senate Bill 94 as detailed in the work session document? Okay, don't see questions. I'd be looking for a motion to amend and do pass with both amendments.
Also move.
Have a motion, a very loud motion from Assemblyman O'Neill, and I heard Assemblywoman Krasner with the second. Is there any discussion on the motion? I don't see discussion. So again, the motion is to amend and do pass Senate Bill 94 with both amendments. All those in favor, please signify by saying aye. Aye. Any opposed, nay? The motion carries. Everyone present voted for the bill, and I will give the floor statement to Assemblyman Wheeler. Thank you for being here, Senator Settlemyre. That takes us to Senate Bill 107. Ms. Thornton.
Senate Bill 107 was sponsored by Senator Orenshaw and heard in committee on May 4th. This bill provides for a 2-year statute of limitation to commence an action in tort for common law wrongful termination of employment. The statute of limitations is told during consideration of any pending state or federal administrative charge on the matter until 93 days after the conclusion of the administrative proceedings. The bill also requires the default statute of limitation of 4 years to apply to certain causes of action whose statute of limitation is not otherwise prescribed by law, regardless of whether the underlying cause of action is analogous to any other cause of action with a statute of limitation expressly prescribed by law. And there are no amendments to this measure. Thank you, Chair.
Thank you, Ms. Thornton. And committee, you might remember this was the bill we heard where there was some opposition that I think was based on a misunderstanding. There was a belief that some existing law in the NRS was being deleted by way of an amendment, which was not the case. The reason I tell you that was I think we heard that testimony from Clark County. They had indicated to me that they were simply misunderstanding the way the bill is operating, so they moved into a neutral position, so they let me know that by email, so they're no longer in opposition if anybody was concerned about that. So any questions on Senate Bill 107 as detailed in the work session document? All right, I don't see questions. This one would be a do pass. I'll take a motion.
I'd move to do pass.
Have a motion from Vice Chair Wynn, a second from Assemblywoman Bilbray Axelrod. Any discussion on the motion? Seeing no discussion, all those in favor, please signify by saying aye. Aye. Any opposed, nay? Could I see the nays, please? We have Assemblyman O'Neill, Assemblyman Wheeler, Assemblywoman Hanson. I believe those. We have 3 nays. That means the motion does carry. Congratulations, Senator Orenshaw. Thank you for being here for any questions. And I'll assign the floor statement on Senate Bill 107 to Assemblywoman Marzola. That takes us to Senate Bill 166. Ms. Thornton?
Senate Bill 166 was sponsored by Senator Scheibel and heard in committee on April 28th. This bill removes a provision from law which requires that in order for certain penalty enhancements to apply to felonies committed because of characteristics of the victim, including color, gender identity or expression, mental or physical disability, national origin, race, religion, or sexual orientation, the perpetrator must not share those characteristics with the victim. Instead, this bill provides that the perpetrator may be punished by an additional penalty if the crime was committed based solely on the characteristics of the victim, which makes the standard for these crimes the same as the standard that applies in misdemeanor cases. There's one amendment proposed by Kendra Birchie and John Pirro. The amendment first amends Section 1 by striking the language by reason of and replacing it with because of to clarify that the actual or perceived characteristic must be the primary cause of the willful violation of certain provisions in statute. Secondly, it provides a definition of because of, and lastly, it amends Section 2 to provide conforming changes. Thank you, Chair.
Thank you, Ms. Thornton. And before I take questions, I'll let the committee know you have an amendment there, and in speaking to legal, I think the amendment is likely going to need some work and some tidying up, which is what legal does on a regular basis when we process amendments. But I just wanted to let committee members know that the amendment that comes back from legal might not look exactly like the one you see on your work session document. We're just going to try to make sure that we're being consistent with how we characterize things in terms that we use in statute. And then of course, you always have a chance to review that amendment before there would be a potential floor vote on the bill as well. With that being said, any questions on Senate Bill 166 as detailed in the work session document? Do you have a question? No, okay, so we'll go to comments in just a moment, but any questions? Okay, seeing no questions, I'll take a motion to amend and do pass.
I'll second.
We have a motion from Assemblywoman Gonzalez, a second from Vice Chair Wynn. Now would be the time for discussion. Assemblywoman Summers Armstrong.
Thank you, Chair, and thank you, Senator Scheibel, for hearing me and my concerns and working with the public defenders to address that, and I really, really appreciate it, so thank you.
Thank you, Assemblywoman. Any further discussion before we take the vote? Assemblywoman Krasner.
Thank you, Chair. I'll be voting yes to get this out of committee. Just want to reserve my right. Thank you.
Thank you. Further discussion? Okay, don't see further discussion. Again, the motion is to amend and do pass Senate Bill 166. All those in favor, please signify by saying aye. Aye. Any opposed, nay? Nay. Could I have a show of hands of the nays? We have Assemblyman O'Neill, Assemblywoman Kasama, Assemblyman Wheeler, and Assemblywoman Hanson. So the motion does carry, and I'll go ahead and take the floor statement on Senate Bill 166. Okay, committee, moving right along, we'll go next to Senate Bill 203. Ms. Thornton?
Senate Bill 203 was sponsored by Senator Dondero Loop and heard in committee on April 28th. This bill sets a 30-year statute of limitation on commencing a civil action to recover damages for sexual abuse or exploitation that occurred when the plaintiff was less than 18 years of age and for injuries suffered by a victim of pornography involving minors. A plaintiff may bring an action against the perpetrator or whoever knowingly benefits financially or receives anything of value from participation in a venture which that person knew or should have known was an act that violates provisions of the bill. A person who is found liable to a plaintiff under these provisions is liable for treble damages as well as reasonable attorney fees. The bill also provides that the mere rental of a hotel room in an establishment of having more than 200 rooms does not constitute a proof of a benefit to a defendant. There are 2 proposed amendments to the measure. The first one was proposed by Senator Dondero Loop and the Nevada Justice Association. This bill provides that in Section 1, subsection 2, that an action to recover damages for an injury suffered by a victim of pornography involving minors may be commenced at any time against the perpetrator. Next, it provides in Section 1, subsection 3, that an action to recover such damages must be commenced within 20 years after the victim reaches 18 years of age. Next, it revises in Section 2, subsection 2, that a person is liable to a plaintiff for damages if the person knowingly benefits financially or by receiving anything of tangible value. It revises in Section 2, subsection 4, the number of rooms to 175 from 200 in a hotel, motel, or other establishment deemed not to benefit or to have gained a benefit from the rental of a room in relation to the sexual abuse or exploitation of another person. And lastly, it revises in Section 2, subsection 5, the definition of sexual abuse and adds the definition of sexual exploitation. The Second Amendment was proposed by Senator Dondero Loop, and she proposed adding Assemblywoman Krausner as a co-sponsor to the bill. Thank you, Chair.
Thank you, Ms. Thornton. And before we take further questions, I had a question actually for our legal in looking at the amendment that's proposed in the work session document. In Section 1, it adds the phrase "against the perpetrator," which was somewhat concerning because it's a civil suit, so we don't usually speak of perpetrators. But I wanted to ask Mr. Wilkinson if we thought that that language was necessary in the amendment or if it was already covered by existing statute.
Thank you, Mr. Chairman. The term perpetrator, as you mentioned, is not used elsewhere in the statute. More importantly, the underlying statute, NRS 41.1396, clearly establishes the person against whom one of these civil actions may be brought, which is a person who promotes, possesses, or uses the internet to access the child pornography. And it also establishes that the person has to be 18 years of age or older, so it wouldn't apply to a minor, and it wouldn't apply to any type of corporation or nonprofit organization or other business entity.
Thank you, Mr. Wilkinson. And so when we get to the motion section, I'll probably ask that we remove those words just for clarity because I think they're already included. But before we get there, let me ask if there are any other questions on Senate Bill 203 as detailed in the work session document. Okay, I don't see questions. At this time, I'll take a motion to amend.
Motion to amend and do pass.
Okay. And Assemblywoman Krasner, is that with the clarification that we'll take out the phrase "against the perpetrator"?
Yes.
Okay, thank you. Do I have a second?
I'll second.
Right, so we have a motion from Assemblywoman Krasner, a second from Vice Chair Wynn. Any discussion on the motion? Assemblyman Orntlicker.
Thank you, Chair. David Orntlicker, Assembly District 20 for the record. I think it's unfortunate that in Section 2.4, we have this carve-out for larger hotels who won't be held accountable for sexual exploitation that they're aware of, but I won't let the perfect be the enemy of the good, and I'll support this.
Thank you, Assemblyman. Any further discussion on the motion? Okay, I don't see further discussion. Again, it's a motion to amend and do pass Senate Bill 203. All those in favor, please signify by saying aye. Aye. Any opposed, nay? Could I see the nays, please? We have Assemblyman O'Neill, Assemblywoman Kasama, Assemblyman Wheeler, and Assemblywoman Hanson. Motion does carry, and I will assign the floor statement to Assemblywoman Krasner. That takes us to Senate Bill 212. Ms. Thornton?
Senate Bill 212 was sponsored by Senator Harris and heard in committee on April 23rd. This bill replaces restrictions on the use of restraint chairs by peace officers and prohibits a peace officer who's responding to a protest or demonstration from discharging a kinetic energy projectile indiscriminately into a crowd or targeting the head, pelvis, spine, or other vital areas of a person. Prior to using a chemical agent, an officer must first declare that the protest or demonstration constitutes an unlawful assembly and then provide orders to disperse an egress route and reasonable time for protesters or demonstrators to disperse. The bill also requires a peace officer to employ de-escalation techniques and other alternatives consistent with his or her training before resorting to higher levels of force to effect an arrest. If an officer uses a higher level of force, the officer is to identify himself or herself as a peace officer, if this can be done safely, and is to use only objectively reasonable amount of force necessary to safely accomplish a lawful purpose. Law enforcement agencies are required to adopt written policies on the threat posed by certain persons to peace officers and to others, and are required to report data on the use of force to the central repository. Law enforcement agencies are required to participate in the National Use of Force Data Collection Program of the FBI, but the data collected may not be used against a peace officer during any criminal proceeding. There is one amendment proposed by Senator Dallas. It revises Section 2 by requiring each law enforcement agency's written policy on the threat that certain persons pose to peace officers or others to include certain information on the use of force. It revises in Section 3.3, subsection 1, by requiring each law enforcement agency to annually make available to the public and on a monthly basis submit to the central repository a report that includes statistics relating to incidents involving the use of force that occurred within the previous month. Next, it revises Section 3.3, subsection 4, to allow the central repository to accept gifts, grants, and donations from any source for the purpose of carrying out the provisions. It provides in Section 3.7 that a peace officer is prohibited from using deadly force against a person based on the danger that the person poses to himself or herself, if a reasonable peace officer would believe that the person does not pose an imminent threat of death or serious bodily harm to the peace officer or another person. It revises Section 4, subsection 7B3 to provide that in response to a protest or demonstration, if there's an immediate threat of physical harm or death to the person, then no order to disperse it must be provided. If there's an immediate threat of harm to property, then only one order to disperse must be provided. And lastly, it makes conforming changes in Section 4.5. Thank you, Chair.
Thank you, Ms. Thornton. And we do have Chair Scheibel here, as you know, to answer any questions on behalf of Senator Harris, if there are any questions on Senate Bill 212 as detailed in the work session document. Assemblywoman Cohen.
Thank you, Chair. My question is about the amendatory language in Section 3.7. So if we're talking about a situation where a family member calls the police because their family member is having a mental health crisis and is making suicidal threats, and that person who's making the suicidal threats has a gun because that's what they're going to use, so they're maybe held up in a room in the house saying, "I'm going to use it on myself. I'm going to do it." And the officer comes to deal with the situation. Does the imminent threat language mean that the person who's threatening to commit suicide has to actually aim the gun at the officer, or we're saying just the fact that they have the gun is not considered an imminent threat?
Melanie Scheibel, Senate District 9 for the record, and I think that's more of a question for legal, but I can represent that in our discussions about it. We discussed a case where somebody does have a gun and that would not rise to the level of an imminent threat just because they have it, if they're making those threats to harm themselves, so it's clear that that's why they have the gun. They would have to change their behavior, point it at an officer, threaten an officer, or something like that.
Okay, thank you.
Thank you, Chair Scheibel. Any additional questions on Senate Bill 212 as detailed in the work session document? Okay, I don't see any more questions at this time. I'll take a motion to amend and do pass.
I'll move to amend and do pass.
A motion from Vice Chair Wynn, a second from Assemblywoman Gonzalez. Any discussion on the motion? Assemblyman O'Neill.
Thank you, Chair, for the time. I want to compliment Senator Harris and probably Senator Scheibel also for being here today on this bill. I know they worked diligently with some of the law enforcement groups to try to refine it. I'll be voting no because I still think there's still some work that needs to be done to get there, and I'm not quite in the yes place, so I'll be a no, Chair.
Thank you, Assemblyman O'Neill. Further discussion? Okay, I don't see any further discussion. Again, the motion is to amend and do pass Senate Bill 212. All those in favor, please signify by saying aye. Aye. Any opposed, nay? Let's see, show of hands for the nays, Assemblywoman Krasner, Assemblyman O'Neill, Assemblywoman Kasama, Assemblywoman Hanson, and Assemblyman Wheeler. Motion does carry on Senate Bill 212, and I'll assign the floor statement on that one to Assemblyman Miller. Just a couple more on the agenda, committee, so we'll go next to Senate Bill 358. Ms. Thornton?
Thank you, Chair. Senate Bill 358 was sponsored by the Senate Committee on Judiciary and heard in committee on April 16th. This bill provides an exception to the general prohibition against intercepting any wire communication for situations wherein a person has barricaded himself or herself, is not exiting or surrendering at the peace officer's lawful request, and there is an imminent risk of harm to life of another person resulting from the barricaded person's actions, or the barricaded person has created a hostage situation. There's one amendment proposed by Assemblyman Yeager. He proposed clarifying the circumstances when an interception or attempted interception of wire communication is authorized, including when a person has barricaded himself or herself or created a hostage situation. Thank you, Chair.
Thank you, Ms. Thornton. And just sort of a point of clarification on the amendment. I don't know that it came out in the hearing, but some of the language that was in Senate Bill 358 was already in NRS in a different statute. I think it was NRS 174, that chapter. So in working with legal and working with the Senate Majority Leader and some other folks who are interested in this bill, I think we found the appropriate solution here in the amendment, which essentially allows for the recording of a phone call only back and forth in these sort of hostage situations. So everything else in the statute would stay the same with respect to having to get ratifications of warrants, but essentially what the amendment does is says in this limited context, it's a one-party consent. So as long as the officer doing the recording is consenting to record the call, then it makes it okay under the laws of our state. And I'll say the reason I did that is I think we want to incentivize recording of those conversations, because if they're not recorded, then the public doesn't have the benefit of the transparency of knowing what those conversations were between whoever is in the hostage situation or barricade situation and the officer. And I think this will ensure that those conversations are recorded and can later be reviewed. So with that very long explanation of a very short amendment, any questions on Senate Bill 358 as detailed in the work session document? All right, I don't see questions, so I'll take a motion to amend and do pass. I'll give the motion to Assemblywoman Marzola, and I saw Assemblyman O'Neill had his hand up, so we'll give him the second. Any discussion on the motion? Assemblywoman Bilbray Axelrod.
I just would like to thank you for that explanation, because I was a little bit squishy on this, I guess is the technical term. And I appreciate that explanation, and I just wanted to get that on the record. Thanks.
Thank you. Further discussion on the motion? Okay, I don't see further discussion. Again, the motion is to amend and do pass Senate Bill 358. All those in favor, please signify by saying aye.
Aye.
Any opposed, nay? Okay, motion carries. Everyone present voted in favor. And I'm going to give the floor statement on that one to Assemblyman O'Neill.
Thank you, Chair.
Thank you. Committee, that takes us to our final bill on the work session at this time, and that is Senate Bill 359. Ms. Thornton?
Senate Bill 359 was sponsored by the Senate Committee on Judiciary and heard in committee on April 21st. This bill provides that if a fire or explosion occurs as a result of the unauthorized manufacturing or compounding of a controlled substance other than marijuana, the person who is engaged in such unlawful activity is also guilty of a Category C felony. Similarly, if a person unlawfully manufactures, grows, plants, cultivates, harvests, dries, or propagates, or processes marijuana or extracts concentrated cannabis, and that activity results in a fire or explosion, the person is also guilty of a Category C felony. There's one proposed amendment by Assemblyman Yeager. This amendment amends Section 1 of the bill to provide that if a person commits a violation of the section by manufacturing or compounding a controlled substance other than marijuana, and the violation causes a fire or explosion, then the person is guilty of a Category B felony and must be punished by imprisonment in the state prison for a minimum term of not less than 3 years and a maximum term of not more than 20, and may be further punished by a fine of not more than $100,000. The Second Amendment amends Section 2 of the bill to provide that the existing penalty for a violation of this section is reduced from a Category C felony to a Category D felony. But if the violation causes a fire or explosion, then the person shall be punished by an additional equal term of imprisonment that runs consecutively to the underlying offense. And lastly, it amends Section 2 by adding language regarding the termination of additional penalty imposed. Thank you, Chair.
Thank you, Ms. Thornton. And committee members, I will let you know I worked with the Senate Majority Leader as well as the public defenders who I believe were in support, but we're still working on the language. So they have seen this language. They are in agreement that this is the best way to go forward with the bill. So I don't know of any opposition at this point, but I will take any questions on the work session document for Senate Bill 359 if there are any questions. Assemblyman Wheeler?
I was just going to make a motion to amend and do pass, Mr. Chair.
Fantastic, thank you. Let me just make sure, no questions on the work session document? Okay, I see no questions. So we have a motion to amend and do pass from Assemblyman Wheeler. Do I have a second? It looks like Assemblyman Miller gave me the second sign, so we have a motion and we have a second. Any discussion on the motion? Okay, don't see discussion. Again, the motion is to amend and do pass Senate Bill 359. All those in favor, please signify by saying aye. Aye. Any opposed, nay? Okay, motion carries. I'm going to assign that one to Assemblywoman Hanson. I feel like I haven't given you a floor statement in a while. So, committee, that takes us through our agenda that we have this morning. Now, before we talk a little bit about what comes next, I did want to make sure we remember to do public comment. So at this time, I'm going to open up public comment. Just by way of a reminder, public comment is, we reserve 30 minutes for public comment, and public commenters will have up to 2 minutes to provide public comment. Public comment is a time to raise matters of a general nature within the jurisdiction of the Assembly Judiciary Committee. BPS, could we see if we have any, well, let me start here in Carson City. Is there anyone here in Carson City who would like to give public comment this morning? Okay, I don't see anyone coming forward. BPS, could we go to the phone lines to see if there's any public comment there?
Good morning. Thank you, Chair. For callers wishing to provide public comment, please press *9 now to take your place in the queue. We will begin with caller with the last 3 digits of 037. Caller, please slowly state and spell your name for the record. You have 2 minutes and may begin.
Tanya Brown, TONJABROWN, Advocates for the Inmates and for the Innocent. Good morning, Chairman Yeager and members of the committee. On behalf of Advocates for the Inmates and the Innocent, we would like to thank you and let you know how much we appreciate your hard work you've put into during this legislative session. We would also like to state that over the years, Nevada has created some wonderful legislation on criminal justice reform. However, there are some areas of criminal justice reform that has yet to be addressed, and my hope is that in 2023, when our legislators come back, that they would look into making criminal justice reform complete by strengthening some of the previously laws that have passed, such as in 2017, Assembly Bill 268, the DNA bill. In the original bill, it was asked to allow DNA testing to be conducted at the inmate's own expense if the court denied testing. There was opposition by the district attorney's office, and that part was removed. The district attorney's office continues to fight against DNA testing, and the inmates are losing any chance of exonerating their names. That was not the intent of that bill. Also, we talk about criminal justice reform. There are several areas of justice reform that needs to be revised, starting from the ground up. And those areas deal with district attorney's office and their qualified immunity, Brady violations without any repercussions to them. When a prosecutor withholds evidence at the expense of an innocent person, they must be held accountable. Prosecuting attorneys must do their jobs if it means going against one of their own. And the statute of limitations must be revised.
And Ms. Brown, we are right at 2
I wanna
minutes,
wish
so
you
if you
guys
could
a wonderful day. Thank
please
you.
wrap up. Thank you so much, Ms.
I'm
Brown.
done.
Thank you.
I'm done. Thank you.
Thank you. Appreciate your public comment. Thank you, Ms. Brown. Have a great rest of the day. BPS, do we have additional callers for public comment this morning?
Yes, Chair. Next caller with the last three digits of 556. Please slowly state and spell your name for the record. You have 2 minutes and may begin.
Anne Marie Grant, ANNEMARIEGRANT, sister of Thomas Purdy, murdered by Reno PD and Washoe County Sheriff's Office. This session, I've asked you to hold police accountable, and some of the bills passed out of this committee are a step in the right direction. I would like to see the focus next session remain on police reform, but also consider the next legislative session on holding prosecutors accountable for their actions. We need to take away qualified immunity. I have listened to not only this committee, but other committees over the session. And over I have heard the DA's response that we have a policy for that type, for any type of legislation that would provide oversight of them. Policy isn't law, and it's much easier to say we are following our policy than to have mandated legislative oversight. When Brady violations were brought up in one hearing, the DA's representative acknowledged that there are no true consequences when a DA withholds evidence. Basically, what the response was is, well, we just never would do that. We would never defy a Supreme Court order. The personal assurance from other DAs that nobody from their office would do anything to jeopardize their good standing just isn't sufficient insurance to the public that justice is truly just and fair. The resistance is concerning. I personally know of a case that the PD in the post-conviction hearing provided a poor and inadequate performance at the hearing. The defendant could not understand why. The defendant was able to understand when he later found out that his public defender already had accepted a job from the appeals unit at the Washoe DA's office, the very unit the defendant was going up against at that hearing. This is unacceptable when someone's freedom is on the line. I'd like to see legislatively mandated wrongful conviction units. The Washoe CIC has reviewed one case since inception and chose to only look at court orders when they should be looking at the entire case, including the defendant's pleadings. If the CIC's lead member stated in that case, the CIC cannot offer a more thorough assessment of your claim than the 12 citizens that served on the jury. A jury that didn't get to see all the evidence, by the way. So if that's their position, why even have a CIC? It appears to be a dog and pony show, and further proof as to why we need legislation on this. If you don't hold them accountable with legislation, nobody can. I'd just like to mention in closing that today is the 4th year anniversary of the asphyxiation murder of Tashi Brown by LVMPD Kenneth LaPierre. Brown died in 2016 after being tased and placed in a chokehold. Please keep his mother, Trinita Farmer, in your thoughts today. Thank you.
Thank you for your public comment, Ms. Grant. BPS, are there additional callers for public comment?
For callers wishing to provide public comment, please press *9 now to take your place in the queue. For callers wishing to provide public comment, please press *9 now to take your place in the queue. And Chair, the public line is open and working. However, there are no more callers on the line.
Thank you, BPS. I'll close public comment. Committee members, a couple of announcements. Last Wednesday was our legal counsel's birthday, Mr. Wilkinson's birthday, so wishing him a belated happy birthday. He's 34 years old as far as I know. And then committee, so for the rest of today, here's kind of where things are at. We've gotten through the agenda. There are 3 more Senate bills that are still sitting in our committee that could be work sessioned today. That is to be determined, but I wanted to let the committee members and members of the public know which bills those are, so you might be ready for them. So the first one was Senate Bill 57, and that was the one presented by Clark County about fines and fees being added to the tax roll. The next one was Senate Bill 317. That was the juvenile justice employees back pay bill. And then the third one was Senate Bill 369, which was the bill, one of the bills relating to bail. So there's still some work being done on those. I don't yet know if we're going to work session those or not. In terms of my best guess, if we do consider those bills today, my best guess is sometime in the afternoon. I don't think we'll have it ready before we get to noon, and then I'm going to be in Senate Judiciary for a little while this afternoon with a lot of work session bills myself. So I would just ask members if you could just remain within 20-25 minutes of the building, so in case I have to call you back, if you could just make sure you're in touch with your attachés, you have your phones on, you're looking at your emails, and so that's where we're at. I just don't know if we're going to do those bills yet or not, to be determined. So at this time, what I'm going to do is put us in recess, and then I will get the word out to all of you as soon as I know. So thank you again for your patience, everyone, and we'll be in recess to the call of the chair.